In Colorado criminal cases, bond or bail, then they're used interchangeably, is set at the first appearance of an individual in court. And the purpose of, I'm going to use the word bail, the purpose of bail is to allow an individual to stay out of custody as opposed to staying in custody during the proceedings in their case. Now, in order for an individual to be released on bail, the defense has to show that the individual is not a threat to the community if released, is not a danger to the community, and also is going to show up for court appearances. Because the issues of bail are whether an individual poses a risk of flight or a risk of presenting a danger to the community. So what I do when I head to court on a bail issue for a client is I prepare in advance all of the reasons why my client does not present a danger to the community and is not a flight risk. Now, if the court deems that there is some amount of flight risk, perhaps an individual has some failures to appear in their past, or if the court determines that that person may pose a danger to the community because perhaps there was a theft or perhaps there was an assault and they're deemed to pose either a financial danger or a physical danger to the community, then the court will set an amount of bail that will allow the court to feel comfortable that this person is going to show up and is not going to cause any harm to the community because that bail amount stands as a deterrent to them either committing a crime or hurting an individual in the community or not showing up to court. For instance, bonds might be set in a violent case at $250,000. And so what happens is that individual needs to post bond, if that bond were set, would have to post about $25,000. Sometimes a bail bondsman will allow 8% to be posted, and then a bail bondsman will post the rest with the court. That means that if my client violates a condition of the bond, which is, for instance, not to commit another crime or to show up for court at the court appearances, and if my client fails to do that, then what the court can do is hold a hearing about the violation of bond, or alternatively may just revoke the bond and hold that individual responsible for that $250,000 that was set. If you have questions about a case that you're involved with and about the issue relating to bond or detention, please call Nancy Kardon at Kardon Law or look at Kardon Law at kardonlaw.com and request a consultation and we can discuss your circumstances.